The dramatic circumstances of COVID-19 pandemic and the need to provide the entities responsible for combating the disease with effective and swift means to an urgent response justified the approval of exceptional and temporary regimes for the award of public contracts. These regimes resulted in several countries in a radical, in my view, sometimes too radical and dangerous simplification of the award procedures. Public procurement is, as well known, a fundamental instrument for the prosecution of public interest. Naturally, its legal framework should be adjusted to the demands of the sanitary crisis, without hindering the responsible entity's ability to act, nor creating unnecessary setbacks to the award of vital contracts to fighting the pandemic. However, the circumstances mentioned require additional caution in order to prevent several risks. Risks of rushed public decisions, risks of decisions that lead to inefficiency and lead to waste of public money, risks of corruption. These are usual risks in public procurement, as unfortunately we all know, but these risks are aggravated, as we also know, during times of crisis. The Portuguese legislator, from the first moment in March 2020, very well stated the need to conciliate procedural celerity with the defense of public interest and rigorous transparency and public spending. The risks of untimely and abusive use of this exceptional regime of public procurement are, however, undeniable, in Portugal as in other countries. First of all, one should take into consideration that this exceptional regime for the award of public contracts in times of sanitary crisis should still, as always, be read and interpreted in light of the European and the constitutional principles applicable to public procurement. In the Portuguese Constitution, Article 266, and in the Portuguese Public Contracts Code, Article 1A. Those principles reflect fundamental constitutional values and establish limits and set guidelines to the choices of contracting authorities. Particularly relevant at this juncture are the principle of public interest, the principle of sustainability, the principle of impartiality, and the principle of proportionality, all of which source of tremendously important obligations to contracting authorities, even, rather, especially, in a situation of crisis. Furthermore, the general European Public Procurement Award principles, competition, equal treatment, transparency, and non-discrimination, harmonized in European law, cannot be unilaterally rescinded by individual member states and have also to be taken into consideration during pandemic. The European Commission approved a communication on the 1st of April 2020 containing guidance for public procurement, in particular for above threshold contracts in the situation caused by the COVID-19 crisis. The Commission suggests a set of measures under already existing public procurement law, comprising deadline reductions, negotiated procedures without publication, and direct awards. It is important to bear in mind Article 28 of Directive 2014-24, which foresees the possibility of a substantial reduction in normal deadlines for reasons of urgency, which makes it possible to speed up the award of the contract. The directive also foresees that the contracting authority will have to access the conditions for the use of a negotiated procedure without prior publication of an announcement, if those conditions are met, having to justify its choice in an individual report. The criteria are as follows: unforeseeable events for the contracting authorities concerned, extreme urgency that makes it impossible to meet the general deadlines, and a causal link between the unpredictable event and the extreme urgency. These criteria must be fulfilled altogether and must be interpreted restrictively. The Commission recognizes in this important communication that until the peak of the pandemic was reached, with the number of patients with COVID-19 needing medical treatment increasing daily, such an event should be considered as unpredictable for any contracting authority. It is necessary to assess on a case-by-case basis whether it is impossible to respect the shortened deadlines of open or limited accelerated tenders, 15 and 10 days for submitting tenders, still required in urgent cases. It means that the exception of extreme urgency cannot be invoked for the award of contracts that take longer than what would be necessary if transparent, open or restricted tenders had been used, including accelerated tenders. And of course, these exceptions can only be used until it is possible to find more stable solutions. That is, it is only a matter of meeting immediate needs until it is feasible to adopt the normal procedures, at least in their accelerated versions. The exceptional regime approved in March in Portugal is applicable to all contracting authorities and include contracts for works, goods and services related to prevention, containment, mitigation and treatment of COVID-19, as well as for all public action needed to restitute normality following the epidemiologic outbreak. Intersecting the objective and subjective scopes of application of the diploma, one should conclude that while in theory it concerns any type of contracting authority, of Article 2 of the Code of Public Contracts, actually only certain entities can resort to this exceptional regime of public procurement. The entities that concretely develop activities for prevention, containment, mitigation and treatment of COVID-19, and that wish to award a contract directly related to that activity, and not contracts related to other aspects of the activity they usually and normally develop. One can conclude that comprised by the exceptional regime is public procurement that relates to and relates from and results from the epidemic outbreak, and not public procurement that derives from needs that did not arise from and because of this outbreak. Concerning the temporal scope of the application of this regime, it is true that the legislator addresses contracts necessary to the restitution of normality. But this does not mean making way for celebrating contracts in post-sanitary crisis periods, nor for without penalty or fraud, introducing in contracts celebrating during the crisis considerably extended deadlines that would allow them to indefinitely be prolonged into the subsequent phase. When it comes to above-threshold public procurement, this regime evidently should take into account the application of simplified regimes contemplated in the directives for cases of urgency and extreme urgency. And let us not forget that the Commission did not give contracting authorities a free pass and ultimately takes the position that existing public procurement law provides for sufficient flexibility. Let's see some of the main measures of flexibilization, acceleration of contract award procedures and the corresponding public expenditures introduced in the first moment, the Diploma of March. The permission to celebrate public supply contracts, public service contracts, and also public works contracts related to COVID-19 by means of a, let's say, normal direct agreement. In some cases, public supply contracts and public service contracts whose contractual price does not exceed 20,000 euros, the permission to award them by means of a totally simplified direct agreement. Usually the limit for this kind of simplified direct agreement is 5,000 euros. The inapplicability to these procedures of the limitations to the successive award to the same economic operator. The exemption in these procedures of the obligation to consult 3 entities prior to the direct agreement. The possibility for contracts to be, regardless of whether they are written down or not, to start to produce all their effects soon after the award. The possibility for the contracting authority to make price advances with no limits. Cases of tacit approval of the necessary expenditure authorizations. The exemption from prior control by Tribunal de Contas, the Court of Auditors. It seems obvious to me that the simplification of public procurement procedures related to COVID-19 was taken too far. Notwithstanding, important boundaries were set. Direct award was only allowed when strictly necessary and due to imperative urgency. That is, if the urgency results from events unpredictable by the contracting authority, if normal deadlines cannot be met, and if the circumstances are not imputed to the contracting authority. One should say, of course, just being in a hurry is not and cannot be a sufficient reason, even in times of crisis, for justifying these exceptional simplified regimes. A crucial limit is also the obligation of contracting authorities to communicate contract awards under this exceptional regime to government members responsible for finance and health, as well as to post information on a site, Portal dos Contratos Públicos, which is very important in compliance with the principles of publicity and transparency. Well, what happened in the second moment, April? This exceptional regime stipulated that exceptionally, as far as strictly necessary and by means of imperative urgency, regardless of contractual price, the totally simplified direct award procurement regime could or can be adopted. So, if in March the limit for resorting to simplified direct award was raised from 5,000 euros to 20,000 euros, in April it became limitless. Moreover, this diploma of April had retroactive effects to the date of the first diploma, which means that the legislator decided to save the contracts that meanwhile had been celebrated. The sole limit imposed in the second moment to the award of these contracts is the obligation imposed on contracting authorities to communicate the award to the members of government and to post the announcement on Portal dos Contratos Públicos. Furthermore, it is determined that after this exceptional period, a joint report on the acquisitions made under this regime is to be drafted and announced on a site of an entity called Serviços Partilhados do Ministério da Saúde. To me, it seems very important to remind that besides all these, the general obligations that arise from the impartiality principle in Código do Procedimento Administrativo, Article 69 and 73, continue to legally bind contracting authorities even in these exceptional circumstances related to COVID-19. In fact, in awarding these contracts, one must prevent, hinder, and sanction conflicts and interests. Illegal award of public contracts must in the future be controlled and sanctioned. After the acute phase of sanitary emergency, which cannot excuse everything, it will be necessary to inspect, to identify, and to hold responsible those who may have unduly benefited during national, global calamity with the award of these public contracts. Another vital limit results from the obligation of the contracting authority to state the reasons for awarding contracts even under this exceptional regime, because that ensures more thoughtful, exempt decisions. It is very important from my point of view that there should be written records for future procedural traceability necessary for controls. Well, in conclusion, public procurement regimes should not, in 2020, help to aggravate the crisis, as unfortunately happened with the approval of the Código dos Contratos Públicos in 2008, but should, once and for all, be thought as an instrument to overcome the crisis in a new logic of sustainability and solidarity. Common good requires that the exceptional and temporary legal tools which the legislator all over Europe envisaged during the pandemic be used prudently and responsibly by all public decision makers who award these contracts, lawyers who advise them, academics who speak out on these issues. The profound economic and social crisis that we will have to overcome in the next years requires that once and for all, there is the boldness and the expertise to use public procurement as a tool for building a true circular economy with sustainability concerns, financial, environmental, and social sustainability, and also with solidarity concerns. Common good demands it. It is urgent.